Welcome to Culturally and Technically Legal, the show where we examine the intersections of culture, technology, and the law. Today, we have a very special guest, someone who I got to put respect on her name. Without further ado, the Honorable Judge Stephanie Sawyer. How are you, Judge Sawyer?
Good afternoon. Very glad to be here.
So happy to have you today. We're going to touch on a bunch of topics. So refreshing to see you as well. I know it's been a little bit of a while, but definitely we'll catch up a little bit through this and just have a general candid conversation. Before we jump into things, do you mind giving the audience a little bit about your background, where you come from, how you got into this space, and so on and so forth?
Sure. Okay, so I am currently a Court of Common Pleas judge in the city of Philadelphia. Court of Common Pleas judge is the highest trial court level before any appellate level. I am a single parent raised by a single parent that knew that I wanted to be involved in providing equity through the justice system, most specifically as an attorney. I practiced, I graduated from Temple undergraduate, Temple Law School. I started off as an assistant city solicitor for the city of Philadelphia for about 5 years. I had a general practice for 18 years thereafter, doing a lot of custody support, divorce, criminal cases, employment discrimination cases. I practiced as a litigator in state courts and federal courts, administrative adjudicatory proceedings. Again, I was a litigator. I was somebody that did case presentation for quite some time. Somewhere around 2011, I began to get a little frustrated with feeling that the judges maybe needed to have a different perspective on the bench. And so I then began interested in becoming a judge because, fighting for individuals one at a time is different than being able to fight for fairness for many people per day. And so that led me to become a judge. I was appointed a municipal court judge in 2014 after running twice unsuccessfully, coming close both times, but not close enough to get the attention of the folks that were in charge of making appointments. And then I was later confirmed by the governor at the time in 2014. I think it was Corbett at the time. As a municipal court judge, but when you are appointed as a judge, you still have to win a term. And so being a single parent raised by a single parent that had to close their office and give away all their clients of a practice that was almost 2 decades long, knowing that if I did not get elected in the next year and a half, I would have to start over, I was a bit distracted. In terms of the program that I created. I just knew when I hit the bench that I was not going to be the kind of judge that fed the beast that is mass incarceration. And so I did not know quite how I was going to do that in 2014. I just knew that for me to sleep at night and look myself in the face, that I knew I had to be a different kind of judge than what most people were used to, because I, prided myself in being a different kind of person than most people in the legal field would encounter. I began on an ad hoc basis, providing unusual sentences that provided resources and some form of follow-up in an ad hoc fashion from 2014 to 2016. And then in 2015, I won my election for Court of Common Pleas and therefore earned a 10-year term, which I began in January of 2016. And with the 10-year term, I was able to focus more on what kind of judge I was going to be. And then after kind of examining how the system maintains a system of mass incarceration, because we all know the proliferation of mass incarceration happened in the 80s and 90s. And here we were in 2014, 15, 16, with essentially the same numbers that had been proliferated in the 80s and 90s. And so my query in terms of figuring out what kind of judge I would be was how does a system maintain the mass incarceration in the fashion that it has? And it became really clear to me that how sentencing and supervision occurs once somebody is found guilty and they have to face a sentencing and supervising judge. Typically speaking, that judge would then either sentence them to probation and send them off to a probation officer, or sentence them to incarceration and send them off to the Department of Correction. 97% or so get out, and off to a parole officer they go. And that the judge that actually pronounced the sentence on that person, the next time they saw them was when a probation or parole officer was so frustrated they were opining revocation, or there was a new case or a new conviction. The next time that judge who sentenced that person sees that person, it's time to punish them again. And if judges are only there for punishment purpose, when in the world do they actually help folks? I didn't take the job to just punish people. I took it to help people. I also realized that by judges only seeing people for punishment purpose, two things happen. You maintain a system of mass incarceration, and you create a wider trust gap. And that trust gap continues to get wider and wider, where judges kind of sit back and wait for time to punish the person, as opposed to actually being part of the solution and helping folks. And so that was when I realized that there had to be a palatable change in how sentencing and supervision would go, at least in my courtroom. And from that information, from 2016 to 2018, we created a program, excuse me, called resource-based sentencing and supervision. Resource-based sentencing and supervision, at its core, it is a system of accountability whereby the sentencing and supervising judge is held accountable to articulate a comprehensive sentence, and for every condition in that comprehensive sentence, provide a cost-free resource to meet that condition, and critically thereafter, have a subsequent status listing to check on their progress, to check on whether or not the reentry resource that was provided was efficacious. And so there was, that is the basis of what resource-based sentencing and supervision is, and what we have utilized it to be. And somewhere in 2020, when I was kind of deflated because the program was running so well in my courtroom, I was seeing people reimagine their lives right in front of my eyes. I've seen parents thanking me with tears in their eyes. I've seen defendants saying it's the longest they've been out of jail, or the longest that they've been sober, or the first time they ever had an apartment of their own, or the first time that they ever had a job of their own, or the longest they've ever kept a job, and were actually helpful and hopeful, and all of those kinds of good things that were going on. I got deflated behind the fact of understanding my place in the sun, meaning I was one of 20 or 30 courtrooms that ran in a criminal court in Philadelphia. And Philadelphia is the first judicial district of Pennsylvania, which is one of 197 judicial districts in one state that doesn't include the federal system. So the deflated feeling came from understanding that I could run this program till I'm blue in the face in my courtroom and never have an impact on moving the needle on mass incarceration, or shrinking that huge trust gap between ordinary citizens and the criminal justice system. And with that realization, I said I had to figure out how to get this program in every criminal courtroom, state and federal. And so in order to do that, there needed to be an entity that could be the logistical support for resource-based sentencing and supervision that would allow that to happen. And after 2 years of thought and getting the right personnel and finding a dynamic board, we were able to do that. September 13th of 2023, we announced the creation of a nonprofit organization and put our paperwork in, called the Sentencing Foundation. And for anybody listening, feel free to go to thesentencingfoundation.org and learn a little bit more about this nonprofit organization that I founded and am the founder and board chair of. And by February of this year, we received our paperwork, and we have a nonprofit, a formal nonprofit organization. And so from there, we went about the business of figuring out how to get the program into other courtrooms. And currently, we are operating in Philadelphia and Austin, Texas. Judge Hernandez is our anchor judge in Texas. We also have judges that are now waiting on their binders, because the Sentencing Foundation has to create the reentry resource network specific to the judge that wishes to utilize the program, in order for that binder to be provided to the judge, so the judge can then begin to run the program. And so we have 5 jurisdictions now waiting on binders. That would be San Antonio, Texas, Houston, Texas, Memphis, Tennessee. We recently last week got a judge in Fargo, North Dakota that wants a binder. Atlanta, Georgia wants a binder. New Rochelle, New York, and of course Philadelphia and Austin. So by I would say Thanksgiving to year's end ish, we expect the program to be in at least 8 different jurisdictions with at least 10 to 15 judges and continually growing, because this is a movement and a mission from my point of view. So does that tell you a little bit about me?
That told me a great deal, and I'm really appreciative of that, and just the level of insight and information that you was able to just share. Within all that, right? I think what I really got really addicted to when you were saying was this different perspective that you take in your courtroom, this alternative perspective, and the work you do inside and outside of the court, right? And you and I both know one of the most important things for a judge is to have a strong level of impartiality, right? And we see it in the media. They talk about it, whether it be on the big news channels of the company certain judges keep, or you watch entertainment and watch a Fresh Prince of Bel-Air, and Uncle Phil or Judge Philip Banks can't have certain connections and relationships, right? How do you balance and uphold that level of impartiality, that non-bias or non-thinking one way or being pulled to the left and right, and still, be an advocate for the people and ensure that there are proper sentencing guidelines that are happening to reform and rehabilitate people rather than to continually punish them?
Well, honestly, that's not difficult at all, right? Because you just, as a judge, you have to remind yourself of what your job is, right? Let me say it this way. For those of you that are not entrenched in the legal community, like I have been for probably close to 40 years, right? 35. Anyway, so
clarify that.
yeah, well, I mean, it is what it is. I mean, look, there's only one alternative to getting old, and so I'll get dusty, crusty. I have no
I love that.
compulsions about being almost 60 years old. It is what it is, right? So back to your question, though. If you understand your job and you stay focused on what your job is, it's not difficult, right? In the legal in a courtroom, it is an adversarial system, right? An adversarial system means there's 2 different sides. There's the prosecution side and there's the defense side, and they have the job of being advocates for their side. They have the job of trying to convince the judge or the jury, whoever the fact finder may be, of what their position is. The judge is just a referee, right? The judge, if they're the fact finder, they have to listen to both sides and address the fact that you have to deal with many different agendas. So, for example, my job is to protect the community, right? My job is to do what's fair for every citizen in front of me, whether that citizen is a defendant or the defendant's family or the victim in the case or the victim's family. So I wasn't hired by a person. I was hired by the collective citizens of Philadelphia who voted for me, right? So if you remind yourself of what your job is and what you're there to do, I'm not there to help or hurt the defendant. I'm not there to help or hurt the victim in the case. I'm not there to help or hurt their children, their brothers, their mothers, their fathers. I'm not there to help or hurt anyone. I'm there to help everyone. And that means that when a person is a victim of a crime, they have to feel like fairness occurred from whatever decisions I make, just like the defendant who has family members that didn't commit a crime have to feel like fairness resulted from a decision I made. So if you remind yourself of your job, then your job is to think about everyone's perspective, and based upon all of their perspectives, come up with what is fair in light of everything you see. Then it's not complicated to remain unbiased, because your job is to not have more sway, more or less sway over any perspective, but to have a balanced approach upon what fairness overall looks like in light of all of the factors before you. So I don't have a problem when I see somebody in front of me that is already so broken that all they're going to do is reap havoc on the rest of the world. I have no problem with looking them in the face and say, ma'am, sir, you're going to jail, right? But if I see somebody that desperation created that crime, and but for that desperation, they wouldn't have committed that crime, then I have to say, well, society shouldn't have to pay for them in jail. Their parents and their children shouldn't have to be without them. They should get the help so that we can remove the desperation and therefore remove the need for the offense. And so it's not rocket scientist work. It's about common decency and common sense on a balanced approach of what fairness looks like.
Yeah, no, I love that response, and I'll just give you one follow up to that. Obviously, we talk about balance and fairness; those last points that you hit on. Now, data is big right now. Everybody's talking about analyzing data. Companies are selling it. People are producing it, sharing it, et cetera, right? Now, data and the way it creeps into the court system, whether it be predictive data, specifying, person A is this age, they've done this, they've been in prison for 5 years, this is what the guidelines should be. How do you manage that aspect of the data, but still be able to supply everything on a case-by-case basis?
That's pretty easy too, because the question is, when you talk about the sentencing guidelines, they are just that. They're guidelines. They are suggestions. They are required that I recognize them. So if somebody says the offense gravity score is X and the prior record score is Y, meaning the sentencing guideline is Z, and that I should sentence them within that Z, okay, I understand that those are what the numbers are. And then I say to myself, what about the individual in front of me? Are the reasons the guidelines are what they are applicable here? Are there mitigating factors? Are there aggravating factors? The guidelines is a starting place to give you guidelines. It is not intended to dictate to the judge what is fairness, because they don't know the person in front of you. They don't know all the attenuating factors of what's going on in front of you. Sometimes there is aggravating factors, and sometimes there are mitigating factors. And so as long as you make sure you make a complete record of why you're doing what you're doing, those numbers becomes mere suggestions. They are not in any way handcuffing me. And I think all too often some judges feel like suggestions are directions that they're required to follow. They're not required to follow them. They're required to fairly consider them. And when you understand that's what guidelines are, and then you superimpose over those guidelines the facts of the case in front of you, then you do your job and create fairness therefrom.
Wow, that was deep, Judge, and we're coming short on time. I want to thank you, and before we let you go, I just want to ask you one general question, specifically for people from diverse backgrounds, whether it be they came up impoverished and they're in this different space now, maybe they be a woman in this different space, and people of color, Black people, Latino people, or people just who feel different in these spaces. What is the importance of bringing your authentic self to work, for you in this case to the bench, or just in anything you do?
When you are kind of divinely inspired to do something, nobody that breathes can tell you to do anything different. And so your authentic self, to be able to find what it is you're supposed to do, you never get to know what that is if you don't start with bringing your authentic self. Who and what you are guides how and what you do. And so my suggestion would be that you are always sending your representative, and you're not ever close to paying respect to yourself if you're not your authentic self, right? I say this a little flip, but I really mean it. And I say to people, anybody has a problem with Stephanie and Sawyer, it's just that, their problem. Go deal with it. So it begins and ends with self. And so if you're not comfortable with presenting and bringing and living and loving and being in your authentic self, then everything else you bring is less than authentic, and therefore the value thereof is also diminished.
Well, thank you so much, Judge Sawyer. That was a very, 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 very powerful response. We greatly appreciate you being here. Just words of wisdom, a lot of jewels and knowledge just dropped and gems dropped that we could take to us in different capacities of life. So thank you again, and definitely look forward to seeing and talking to you again soon.
Anytime. You have my number, and like I tell people all the time, I never promised to call you, but I will always call you back.
Yes, indeed. Yes, indeed. I appreciate that. And thank you, audience, today for watching another episode of Culturally and Technically Legal. Be on the lookout for the next episode. I'll be back at you soon. Thank you again. Have a good one.